Okay, well, let's continue on with false imprisonment as the next intentional tort. And all the ones we're talking about right now are intentional torts, which means that the plaintiff is able to recover not only compensatory damages but also punitive damages on top of the compensatory damages as well. False imprisonment is about what you would think. It is the confinement of another without justification. It is a situation where you are entitled to detain certain persons for a reasonable period of time when there is justification to do so. And the law says, for example, that a shoplifter or a suspected shoplifter can be detained for a certain period of time with probable cause. Could you keep someone, detain them for 10 minutes while you interrogate them? Absolutely. Could you interrogate them for 10 hours in the store without allowing them to leave a locked room? No, you could not. So somewhere between 10 minutes and 10 hours is the line. I don't know where the line is, but it's somewhere between those times. Also, it requires an indefinite period of time. If Mr. Cartwright decides that you have not quite learned enough and decides to lock the door to the classroom when the time expires for the class to end and hold you there for another 2 minutes, it's probably okay. Please don't sue Mr. Cartwright. On the other hand, in the event that Mr. Cartwright holds you there for 4 hours after class, then yes, false imprisonment probably has occurred. In addition, it depends on the circumstances. If there is smoke that is billowing out of the building and the fire alarm is going off and flames are showing up in the distance and the building is on fire, then certainly even a 2-minute locking into the classroom is probably enough for a false imprisonment claim to occur. The next intentional tort is infliction of emotional distress. And in this one, the courts require extreme and outrageous conduct. I like to think of these as your very severe practical jokes. You have someone that places a dead mouse in a bowl of chili, and someone thinks it's funny, and they take a bite and see it get sick and throw up. The throwing up is a physical symptom, and if a court, as some courts do, require physical symptoms in order to substantiate the tort of intentional infliction of emotional distress, then that will qualify. Crying, nausea, vomiting, that kind of thing will also count. Let's talk about defamation next. It's the next intentional tort. Defamation as an intentional tort is the wrongful injuring of a person's good reputation with the use of false statements about them. And there are a number of different things that are inherent in what I just said. Defamation requires a false statement. You've heard, I'm sure, the old saying before that truth is an absolute defense, and that's exactly right. Truth is a defense to a defamation action. In addition to truth being a defense, you also have to have certain elements of defamation, such as publication that occurs. And publication is a legal term of art. Publication in this sense means the dissemination of information or facts, all being false, of course, to a third party. Third party must hear, see, read the statement, something like that, that damages a person's good reputation. Let's say that you have a person, one student calls another student a slut who sleeps around with everyone in the class. Number one, if the statement is a false statement, then potentially you have a defamation action. However, what if that statement was made directly to the second student in the elevator as they ride the elevator down, leaving the classroom? Nobody else on the elevator. If that's the case, the element of publication would be missing, and defamation would not be substantiated as a tort. I had a case once in which my client had written a letter to another person accusing them of engaging in certain crimes. The other person sued my client for various things, but one of the claims they made was defamation, claiming that we had defamed him through these allegedly false claims of committing a crime. What was missing there? Publication. Since it was a letter that we wrote to that person and to nobody else, then there was no publication. If the plaintiff in that case had chosen voluntarily to share that information with others, they were the ones doing the publishing, not us. We didn't publish it. We sent it directly to them. What about a posting that someone makes on the internet? An anonymous posting on a message board as Big Alabama Fan 68, and they allege that the Auburn football coach has engaged in crimes of various sorts. Can they be held responsible for defamation? They certainly can. And I would also caution anyone that if you think you're anonymous on the internet, someone can find out who you are every time. Guaranteed. Let's talk about the statements themselves. The statement must hold someone up to contempt, ridicule, or hatred in the community. It has to be something that's damaging to them. There is a form of defamation known as slander per se, and this is one of those rare situations when you don't even have to prove damages, but you can still recover. And defamation in the slander per se category involves one of four different areas. That you have accused someone of loathsome communicable disease. Hey, that girl's got venereal disease, chlamydia, whatever. You accuse someone of professional impropriety. Hey, Mr. Cartwright steals money from his clients. You accuse someone of having been imprisoned for a serious crime. Yeah, that guy's a convicted rapist. And you accuse an unmarried woman of being unchaste. She's a slut that sleeps around, etc. All of those are what are known as slander per se, and slander per se is a form of defamation that does not even require damages to be shown. I'm going to quickly kind of go through invasion of the right to privacy, but basically you'll see this used in a number of different ways, and it is an intentional tort. The law says that we are all entitled to some privacy rights, and that when others breach that privacy, then they have committed an intentional tort. And there are different types of it that are listed there below. Public disclosure of private facts is one that I find interesting, and that basically says, look, sometimes if you publicly disclose private facts, facts that are private, held private, even if it is true, an intentional tort has been demonstrated, even if true. If it's false, defamation has occurred, but even if it's true, another intentional tort may have occurred, and that's public disclosure of private facts. Picture, if you will, a peeping Tom looking into a bedroom window, seeing someone engaged in certain deviant sexual acts, and during those acts, the party that's peeping in takes a video, and they publish that video on the internet. That very likely would be a case of a public disclosure of private facts giving right to an invasion of the right to privacy. We're going to go on to fraud next. And I also have a separate handout / short integrity audio lecture on reliance when we get to this part, and you'll understand why in a minute. But look for other information on top of the information that you have here. Fraud is an intentional tort. It is a misrepresentation intentionally done of an existing fact, a knowing misrepresentation of a fact. That's number one. Intending to induce someone to rely upon that. That's number two. Number three, and rather than saying justifiable reliance, I'm going to just say reliance, because there are two different types of reliance. I'm going to talk about that in a minute, but we're going to say the third element is reliance by an innocent party, and the fourth is causation and damages. Brief example. Let's say that a person is at a car dealership and they want to buy a car. The salesman says, I have a 2012 Honda Accord here. And the salesman knows it's not a 2012 Honda Accord, it's a 2009 Honda Accord. It's 3 years older. The car's not worth as much. Salesman lied to them. That's number one, a knowing misrepresentation of fact. The salesman lied to them because they wanted them to rely upon that fact, so they met the second requirement, which is intent to induce an innocent party to rely. Let's say you don't know any better, and so you take their word for it that it's a 2012 Honda Accord and not a 2009, so you relied upon it, that statement. And a lot of times you see that as reliance to your detriment, or detrimental reliance. You relied upon it to your detriment. And the fourth element is also met, causation and damages. You bought the car, assuming you bought it, relying upon that misrepresentation, and you thought you bought a 2012 Honda Accord when in fact you bought a 2009 Honda Accord, which is not worth as much. Justifiable reliance is listed here. We do not, in the state of Alabama, use justifiable reliance. There are basically two types of reliance. I'm going to mention it briefly here, and as I said, I've got a separate handout / integrity audio lecture prepared for just reliance, so more information can be obtained from that. But basically, jurisdictions use either the concept of reasonable reliance or justifiable reliance, and they sound similar, but they act very differently in operation. Let's say on the example that I just gave related to the car purchase. And let's also say that when you bought the car, you had to sign a contract for the purchase of the car. And in the contract somewhere, it said the car was actually a 2009 Honda Accord. May have been on page 6 in small print, but it was there somewhere. Well, the law says in a reasonable reliance that a party is not entitled to reasonably rely upon a verbal statement by a salesman when there's something in writing that contradicts it. In other words, the writing trumps it. The writing controls. They say it's not reasonable to rely upon that verbal statement if there's something in writing that contradicts it. On the other hand, if you're in a justifiable reliance state, as the majority of states are, the law doesn't look at it that way. Instead, they say, look, were you justified in relying upon the car salesman? And if you remember, when we've discussed things like the McDonald's case before, we said that there are no such things as boxes or things in corporations. It's people. You act through your people. And in this case, the car dealership was acting through its car salesman, who was an authorized agent and could speak for the company and did speak for the company. And he spoke for the company by lying to the customer. And the law says, hey, you are justified in relying upon that statement made by the salesman. So justifiable reliance would say you could sue and recover. Reasonable reliance? Probably not. The bottom of this slide says contrast puffery or statements of opinion. And briefly, the puffery is where a salesman or someone touts something as great, wonderful, etc., and it's not really a statement of fact. Let's say the car salesman said, oh, that Honda Accord is going to be the greatest car you've ever owned. That's puffery. That's going to get great gas mileage. That's puffery. That's going to be the smoothest car you've ever owned. That's puffery. Even if the Honda only gets 22 miles to the gallon and you're expecting to get 35, that's still okay. It's not a knowing misrepresentation because great gas mileage is just puffery. It's a statement of opinion, and it may differ from person to person. Now, on the other hand, what would have made that fraud? Well, let's say the salesman had instead said, look, this car will get you a minimum of 30 miles to the gallon, guaranteed. And more than likely, it'll get 35 miles to the gallon. That's a case where there may be a knowing misrepresentation, assuming that the salesman knew that, in fact, this particular Honda only was going to get 22 miles to the gallon. We're going to skip negligent misrepresentation for now and move on to wrongful interference with contractual relationship. I had a case once where I represented a tobacco wholesaler. They sold cigarettes, cigars, chewing tobacco, snuff, etc. to convenience stores. And long story short, but the former employer of my client wrote letters to our customers threatening to sue them if they did business with us. Our customers dropped us left and right, and we sued our former employer because we said, look, You knew we had a valid contract with these convenience stores, and you intentionally caused our customers to drop us, to breach. A breach is a break of promise, to breach the original contract. And arguably, we were correct. I think we would have been proven correct. The case ended up settling where they paid money to us as a result of the settlement, and it did not go to trial. But I think we would have been shown correct. In class, I'll tell you a little bit more about that particular case because it's interesting and I think highlights some of the points a little bit better. Now let's move and change our focus from intentional torts to the case of unintentional torts. And unintentional torts are known in the law as negligence. And negligent torts allow the recovery of only compensatory damages. That's all. It's not considered by the law to be intentional conduct. It's on accident. Basically, you have a situation where you have a duty that is owed to a party. There is a breach of that duty, and when that duty is breached, it causes injury to another. I'm going to give you an example. Give you an example of how this applies, and you still have judges that use this analysis from time to time, and it's basically typical tort law. Let's say you're driving your car on Valleydale Road on the way to school today, and you owe a duty to everyone on the road to drive your car in a reasonably safe manner. If you are texting or driving in an excessive speed, or perhaps even driving your car with bald tires or whatever, and you are therefore breaching your duty to drive your car safely, you have not yet committed a tort of negligence, but let's say as a result of you driving unsafely, you're texting and you're looking down and you don't see what you should see, and you run into a car pulling out on the road. You have now caused an injury as a result of that breach of duty, and as a result, the tort of negligence has occurred. And I'm going to back up here in just a second and point out that trespass is an intentional tort. I skipped over it. I'm going to briefly mention it and pick back up. It is an intentional tort. The law itself says that trespass is almost sort of a legal fiction. You normally have a damage that's occurred as a result of an intentional tort. Well, in a case of trespass, what's the damage? You've got someone that walks onto your property without your permission. They're trespassing. Well, how's that been damaged? Have their footsteps really hurt the property? Usually not. What if they climb over your fence because you've got some hunting land and they go hunting there? Have they damaged you? Probably not. But the law says this: you have the right to the exclusive use and enjoyment of your property to the exclusion of everybody else in the world. Nobody else has that right but you. And they've taken that from you. And as a result, the law says that you've been damaged. So that can be a trespass, that can be an intentional tort as well. I'm going to skip to the bottom: disparagement of property. slander of quality and slander of title. These can be pretty good intentional torts as well. Many years ago, there was one beer company that allegedly their beer was polluted with urine from their workers. And it turned out it was a nasty rumor started by the competitor of that beer company. Well, they were slandering the quality of that property. And that's an intentional tort, as you can imagine. Slander of title. Best example I can give on slander of title is if, for example, you believe someone owes you money, they won't pay, and you go down to probate court and you file a lien against them without going through the proper channels. And typically you'd have to, unless the law allows a specific type of exception, you'd have to go and you'd have to sue them, and you'd have to be successful in the lawsuit and get a judgment, have the judgment become a final judgment, and then file that judgment in order for it to act as a judgment lien. So if you skipped all those steps and you keep them from being able to convey good title, trying to sell their property, their real estate, their home, or whatever, that can be a slander of title as well. I'm sorry I skipped over that. But I did want to pick those things up as well. Let's go back to negligence, and there you see the analysis that I've already discussed. Was there a duty of care that was owed to people? In this particular case, to the plaintiff. Did the defendant breach that duty, and did the plaintiff suffer a legal injury caused by that particular breach of duty? The duty is based upon a reasonable person standard. I told you the first day of class we'd be talking about reasonableness and the reasonable person. The law very rarely deals in fairness, but very often and very commonly deals in reasonableness. How would a reasonable person have acted under the circumstances? Again, I have a separate handout related to landowners and business invitees versus licensees versus trespassers, and I would encourage you to review that handout and the materials related to it for very specific legal standards that apply to that. And I'm going to skip over for now on this and ask you to supplement this lecture with the additional material provided. I'm going to talk about just a couple more different principles, and we have at the middle of this slide, contributory negligence and comparative negligence. I typically have discussed this in connection with the Lebec versus McDonald's case study. Generally speaking, contributory negligence, few jurisdictions, and I think we're down to one, being Alabama, says that if the plaintiff is at fault at all, any percentage, then they recover nothing. They are barred from recovery. In comparative negligence states, which are the majority, as long as the plaintiff is less responsible or less at fault than the defendant, or they say it 50% here, but it means the same thing, then they can recover a pro rata share of the damages that have occurred. It's basically reduced by the percentage they were liable. If you recall the Lebec versus McDonald's case study, Ms. Lebec recovered a judgment of $200,000 in compensatory damages against McDonald's for producing too hot coffee, injuring her. However, it was reduced 20% or $40,000 because the jury determined she was 20% at fault. Since New Mexico was a comparative negligence state, that applied to reduce the $200,000 judgment to $160,000 that she could recover. Okay, I want to mention assumption of the risk. Assumption of the risk is a legal doctrine that says when a plaintiff has assumed a voluntary and known risk, they cannot successfully sue to recover damages in that event. Best example I can give is a sports example. If you go to Regions Park and go watch the Barons play baseball, the baseball game that takes place will involve baseballs being hit and thrown, and sometimes those baseballs will come flying out of the playing area into the stands. In fact, my kids like to go to the games just so they can try to catch one of those foul balls. Well, if you are hit and struck by a flying baseball, that is a risk that you have assumed by going to the game. You know that can occur. That's a known risk, and you have voluntarily assumed that risk by going to the game. If you didn't want to voluntarily assume that known risk, you didn't have to go to the game. No one forced you to go to the game. You did that on your own. It has to be a known risk. Now, if you go to Legion Field and you're watching a football game and a portion of the upper deck, or what used to be the upper deck, falls on your head, that's not a known risk, believe it or not, that you have assumed, and they probably would be liable to you for the injuries that have occurred. The last thing that I'm going to discuss is slide number 20, and it has some special negligence type doctrines. The first one is known as res ipsa loquitur, and that means the thing speaks for itself. Res ipsa loquitur is a special legal doctrine in which the law says that when something is in the control of the defendant, in the sole and exclusive control of the defendant, and the plaintiff is injured through circumstances that ordinarily do not occur without the negligence of someone else, then the law presumes the defendant was responsible unless they can show otherwise. It basically is sort of a burden shifting type statute. And that's a lot of words, and it may be a little confusing, but I think an example will clear this right up. Let's say that a plaintiff walks into Acme department store. An Acme department store sells those big 60-inch TVs. And plaintiff is looking at televisions, and while they're looking at a television, a big 60-inch television from a shelf above them falls off the shelf and hits them in the head. Acme department store was in exclusive control of securing that television set. Nobody else was in charge of it. They were. Their store manager or their clerks or whoever was responsible for securing that television set, bolting it down, tying it off, making sure the shelf was adequate to hold it, in all other aspects, needing to make sure that the situation was safe. Somehow there was a failure. Maybe it was that it wasn't tied off. Maybe it was that the bolts weren't screwed in completely or the nuts tied down. Maybe it was that they didn't use a washer. Maybe they used washers that were not sufficient or bolts that were not sufficient. Maybe the shelf was inadequate to hold the weight of the 60-inch TV. Doesn't really matter for our purposes because the plaintiff just says, Judge, res ipsa loquitur, The thing speaks for itself. This is the kind of thing, TVs don't come falling on people's head unless somebody was negligent. It was in the exclusive control of Acme department store. Acme is responsible. The next one that I'm going to discuss is danger invites rescue doctrine, and I'm just going to be brief on it, and then the last one will be negligence per se, and I'm going to skip Dram Shop Act and cyberspace for now. Danger invites rescue doctrine is sort of a Good Samaritan type of protection law that has developed over time. And let's say that you were involved in a car accident and you're lying unconscious in the car, unable to get out, and the car is burning. And someone comes to rescue you and they get burned as they pull you to safety. Can they sue you as a result of their injuries? They probably can. And the reason is that you owe a duty to be in a non-burning car, a car that won't burn someone. You say, well, it's not my fault. Well, you were in the car accident. You created the danger, and danger invites rescue, meaning that rescuers are entitled and encouraged to come and try to help. And part of the encouragement is the recognition that they would not have to suffer the burden of their own injuries. You remember the first day of class, I said that in law and in life, bad things happen, and the law has to decide who should bear the burden of that bad thing that happened. The rescuer is trying to do a good deed, and they had a bad thing happen to them. They became burned. Who should bear the burden of that? The rescuer or the person who put them in that danger? And the law says it's the person that put them in that danger. Final topic, negligence per se. Negligence per se is a legal principle that says that if there is a law or statute or regulation that is designed for health or safety, for the protection of people, health or safety wise, and the person injured is in that class of people who are designed to be protected by that statute or regulation or law, then all you have to do is show that the statute was violated, and that is proof that they were negligent. Again, a lot of words. It'll make more sense. It's easier with an example. Law says that meats must be packaged with a date where the meats can safely be sold and consumed. Let's say that a retailer decides to rewrap the meats and doesn't put that sticker on there that tells the purchaser when the meat is goodbye. If that's the case, the law in that situation is designed to protect consumers, people that buy the meats and people that eat the meats that are purchased by the consumers. The statute is designed to prevent injuries to those parties. And if you eat purchase the meat that's been expired and the injury occurs, then that's all you have to show. You don't have to show that it was salmonella as a result of so much bacteria being presented from this date, and if it had been this other date, it would have been fine, etc. Negligence per se kicks in because they violated the statute or the rule or the regulation that was designed to protect the public. And that's all we have for this tort lecture. Thank you so much.